I think we'll let the record show that y'all came in and presented this problem to us, and we'll probably have to go with however Miles advises us to do.
You know, the right way to do this is going through circuit court, okay? Filing a civil action. You said you have deeds going way back showing that you do have some rights upon this. The government, even if we want to, we cannot mandate neighbors to be nice to each other. We can't tell one person who has land that they have to let another person use it, even though that other person uses it. However, that doesn't mean a court can't. America always wants people to be able to use their land, and that's where that's coming from, what's called an easement by necessity. If you're landlocked, then you can petition a court, the circuit court in that county, to give you a right to pass over somebody's land. As a fiscal court, we can only do what we can do based upon our rights and our jurisdiction. If this was county land, if it was county property, yes, I'd send them a letter saying if you don't take it up, then you know you might find yourself in jail. But if it's a property dispute, if it's a gate up, if it's something like that, and we've never had it as a county road, then we can't make anybody be good neighbors, okay? However, I did say that I think that they have some cause to believe that they could win this in circuit court, and that they could get an easement by necessity, in which point the other side couldn't keep them from using their land. This second option, just to tell you all, if it is a public use, the way everybody says, and it serves people, you could always take it into the county road system. But short of the government owning something, we can't tell one landowner to move their gate so another landowner has an easier route to their land. But if you wanted to take it in the county road system, then you would need to do it by those proper procedures.
Also, there is this road will also lead to government land in behind us. So as far as government, I mean federal government. But anyway, Harold, you can remember this, now I can't. But was that road considered county and public use when Lance and Gene? Did you ever remember the county maintaining that road?
Years ago, they did.
What?
They graded.
They graded
Years
it, that's
ago,
all
they had this grade.
There's a public use exception, not only with the easement by necessity, and this is not mandated by the county. We say if a road is a county road or not. We don't say if a road is a public use road or not. That would be designated in a civil judgment that you would get from Judge Phillips. But as far as the fiscal court, people think that we have control of the whole county. We don't. We have control over the government property, not everybody's land. We can't tell them, even if they are being a bad neighbor, even if, whatever. You got to kind of do it the right way. And as I said, I think you all do have a good case. And if the fiscal court wanted to turn it into a county road, that would also be an option. But, right now, I think that you'd probably have to proceed civilly.
Well, would you guys consider putting that into the county system so that Marty didn't build his house down there because it wasn't, he couldn't get into it. So,
We'll take a look at it and see. We haven't been putting anything in lately because of cost.
Well, I don't think he's asking to put 6 foot of gravel on it.
Does Marty live down there now?
No, he doesn't now, but Cheryl couldn't even build her house down there if she wanted to because she couldn't get through. You can't get through. She can't sell that. They can't sell this farm because you can't get through. Who wants to buy a farm when they already know that the one that you have to go supposedly through, he won't let you through. Now, how many of you going to buy one of them? I've sold real estate for many years, and I've yet to sell one, had any problem with the right of way or the easement. But you all can take it into the system and bring it off. But it's not, and it's only.
How much of it will we have to take in, Liz?
About 1/8 of a mile. How far is it, you guys? I'm not good with measurement.
It's eighth or less, and it's a dirt road. We're not cutting through a grass field. This is a wore-out dirt road that's been traveled religiously up until November.
And the banks of the road, the banks is cut off, Chestnut, West Street.
We're fourth generation to use this road, or fifth generation to be in place. The fourth generation that I know for sure has used this road.
This probably has been a county road.
All over the counties use this road.
Yeah.
It's probably been a county road, just never was on the list.
Could very well be.
I've been through there, what they talking about.
If it's on the deed that it was turned over, that part for transportation from landowners,
I'm sorry? I didn't hear you.
does the deed say that, different deeds say that a certain part of the land is turned over for public transportation? That's what I go upstairs and look for when I,
Okay, well, we just looked at his, I wanted to see if it said anything about that road on his deeds. They have.
Yeah, that's another thing I wanted to kind of help you on, draw your attention to. When people write up deeds and they say, somebody else owes me something on this deed, that don't really have any power. What would be the power is the deed that had that easement given to them. So if his deed said this is a public right of way, blah, 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 then you could use that in court. I mean, he should probably give up at that point, okay? So I would go take a closer look at not your deeds, but his, because that's the property that has the encumbrances on
Jacked
it.
around so much with,
These people that swap property.
yeah, they bought property, it's
It's what
a
property?
boundary deed, and it's been jicky-jacked with the previous owner and owners, that they're actually claiming Sonny Rose's family's property too, they won't let them in.
You could do a title search on, you can do
Oh, I
a
know
title search
that,
on
but
somebody
what
else's
I'm saying is
property.
I can't go by, I'm afraid that when we go in and start doing the descriptions, they've been jicky-jacked with because this was held out for that. And when you start doing that, that's when you can slide something in or out and make it, well, that's, that is a boundary deed.
Yeah.
That's where they hit you.
Does the right of way now go through his property, or just to the end of it?
I haven't looked at the deeds. I'm just going by everybody's description.
His property comes from the center of the ridge, and which actually the center of the ridge is right
Center
there.
of the ridge is fence road, the road is cut down over
Yeah.
years of gravel.
Yeah,
But you can lean back and look at Center Bridge, I mean, that's just all it's about.
I didn't go down there.
they go back
I read
to
through
previous
this.
owners. If
If it's a property line dispute, you're looking at surveyors. If it is encumbrances upon the property, you're looking at a title search. Sounds to me like you've got problems with both. They're saying that it's been messed
Yeah.
up, and you're also saying that there's been a lot of stuff being recorded, so you're looking at a very complicated property dispute case.
Is the gate on whose property? He says it's on his, okay? And it's 9 foot 8 inches, right? Okay, so as long as, if I put a gate over on, if I put a post over on my property on 772 and Terry Williams puts a gate post on the other side, we can stop traffic on 772.
No, because you wouldn't own 772.
But I've got the gate post on me.
It doesn't, but you're stopping 770, you're stopping people on a government right of way from getting through. What he's doing is he's saying, I'm stopping people from getting through my property.
Well, that-
Even though it might not be his property, I'm not saying it is, I'm not saying it isn't, okay? I'm just
If I
saying,
mean, if I wanted to be like him, and Terry wanted to be like him, which we're not, okay, I'm just using this as a synopsis, then we could do the same thing. Because he says that that gate is on him. It's actually on this public pathway.
well, the public pathway has never been designated, even though, I believe every one of you, I know you, I know you're here telling the truth. Even though that it has been, it might have been for 100 years, there's not been a judge, a fiscal court, or anybody designated as such, okay? So you would have to get that designation, and that's what you'd get through civil court, civil court.
Do we have to file suit to go before the judge, or
You'd have to file suit, yeah.
do we have to file suit to meet with our duly elected circuit judge? We have to file suit before we can bring her the copies of these deeds and try to get her to uphold what is legally right.
Well, it's a whole process, when
So in other words, we got a lot.
when you sue somebody, you have to tell the other side you're suing them. You've got to give notice of when, the hearing's going to be. You got to give the evidence that you have. You got to tell the judge, when it's going to be. You got to tell, the court, so everybody can be there. So yeah, you would have to pay money to the court in order for them.
I'm not worried about paying money to the court. It's been these kids are gonna be out $5,000 in order to get to their farm because of someone else's stupidity. And if they're gonna win, because that's the right thing to do, that's the right, that is what is right. And they're gonna be out $5,000, and he's gonna be skipping on the Blacktop Road, going, ha, 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 cost you money.
Well, he'll probably have to pay too. I mean, I don't know his situation, but usually when you get sued, you should probably get a lawyer. I can't speak to that. Morgan County, I can say, the fiscal court, we can't really mandate that he open up the gate. There's no mechanism for that except making it a county road. And I don't speak to that or anything like that. There'd have to be, whatever that is. But I'm just saying, if we wanted to, if every one of us wanted to, we can't order him to open up his gate. If there's a property dispute, fight him on that. If it's an easement issue, fight him on that. I mean, it's just...
Passage, it should be, he is taking advantage of what he's been told and not surveyed. So, from the prior owners and the prior owners there. Because,
And if he's claiming land that's not his, then the real property owners, they're going to have to challenge him. They're going to have to get a survey. They're going to have to take that to the circuit court as well.
anybody know how to get hold of Sunny Road? It's his way.
He lives over on Wells Hill, them little hospitals,
Very most is in control. Okay.
Sandy, how far back does the record you all got here?
I don't know.
For how far back?
I really
Got
don't.
them back to, say, 78, 79, or 80?
Are you talking about,
Fiscal court records.
we've got them, I guess, as far back as they start having fiscal court, haven't we? It's in in Randy's office.
They don't go back to that term, see?
Is that public record, or do we have to?
Oh, yeah.
Public
Yeah,
record.
public
It's in
record.
our
In your office? Okay.
Go
And
back.
as I said, what's also in their office is the other person's deed.
Yeah, but like I said,
If that shows an encumbrance upon that deed, that's important because you can use that, okay? Encumbrance is shown upon your deed. You got a deed saying, okay, I own this land, and you can travel across your neighbor's land. That don't really mean nothing because you're saying, you're giving up something that's not yours. So you have to go to the person that's actually giving up something, whether it was back in 1938 or 2015. Take their deed, show the encumbrances on it, and then use that to get your easement or your public passageway.
So now, what was you, what would you do? You had property back there, I mean, you go, along your, what would you do? You go back there, right?
Yeah, I would litigate it. I mean, if
If you had a farm that was about to grow up and you couldn't get to it with a bush hog, are you gonna let it grow up?
I would do my best to not let it grow up, but still obeying the law. I don't want to, set off here like I would do anything because you've got to follow the law.
Come and get, you're gonna get in jail.
So Miles, Miles,
Had to go there, I don't have no more bush hog. I took the day off.
I told you, he's good, we're not.
They dirty people, they want no trouble. You could have no better neighbor. They just want to do something for the law. Me and her, I'm 57 years old, I just don't care. You don't want no more extra. That's the way I am.
so Miles, if I buy a big farm,
And the boy would have had enough guns about it.
if I buy a big farm,
You don't want.
And I turn-
He won't be paying no property taxes to the court here, by the way.
and I turn part of that over to the county as a right of way, and then Liz buys it from me and she decides she doesn't no longer want anyone to travel, can she do that? If I turn it over before, when I own it, I turn it over part of it as a right
No,
of way.
she can't get it back.
Well, that's what it
unless-
sounds like he's doing, is it's been a right of way for some time, and then
That would
he
be in the
buys it,
deed.
and-
That would be in the deed. That would be in the deed. That would be in the title search. Title search is saying that this happened, that you gave up this encumbrance to your property. People could go through your land, easement, public passageway, or whatever. That would be the only way. You can't get that back once you do it unless you buy the other land and it disappears.
So if I turn it over to a right of way and it's been used that way for 50 years, and she buys it and says, well, I don't want people to travel down longer. She can't do that, can she?
Not if it's, as I said, you can go back to that deed where she said, I'm giving this away, and you can use that in court. But you can't just say that people travel across. I could let people travel across my land for 20 years. I say, you can use it. And then on the first day after 20 years, I say, I put up a gate and say, you can't use it. We can't mandate people to be good neighbors. You know, we can only mandate that roads stay open that we own, not that other people own.
Miles, if we want to, vote to make it county road on out in there, would he have to sign it, or before the right away, what we do on that?
We would have to, it sounds to me like he doesn't want that to happen, so we would have to force it. We would have to eminent domain and say that it was for the public good and that it served a portion of people that we needed to get a road to. So eventually, the government can take land from people, but it has to be for very, very good cause, okay? And they have to be paid for it, and they have to be notified that it's going to be taken, and there's a whole bunch of steps when you start, taking something from people. So, yes, it can be done, but I'm not going to sit here and say it's easy. As I said, the easiest thing for them is to either find in the deed where the property was given up as a public passageway, and then boom, you won. Or they can apply for an easement by necessity because they can't get to the property through no other means. Okay, the public passageway, all that's options, but we can't do it fiscally, other than making it a county road.
If we find that it has been and it still is in the system, like it's a dormant, we'll call it, for lack of a better word, then you all can make it move the gate. Are we right about that?
If it's a county road, yes, there's laws that say you have to keep county roads open. That happened, I believe, last fall or spring here in Morgan County. We did the same thing. So as long as, if the county's put gravel on it, if we maintain it for 15 years or longer, or it's a county road, it's illegal to block those.
Somewhere in the deeds, it may refer back to that, and that's all you'll have to get.
That's what we've got, public passage. But he says it's not, it won't.
Yeah, I can't have a deed to my property that says my neighbor owes me a public passageway,
No,
because
this says his property line goes to the public passway.
that's what I'm saying. It would be somebody, your property, a deed can only encumber the property that it's telling about. If it's saying it goes to a point, but that point is somebody else's property, or that point is a public, but it's saying that public passageway is being encumbered by this deed. The deed can only, the four corners of that property is the only thing a deed talks about. So its borders have nothing to do with that deed. It would have to be the other deed. That other deed that has a public passageway on its land would have to encumber it. Okay? I could say, I could have a deed, I could draw it up and say, I own my neighbor's property, and it could get signed and everything. It doesn't matter. You can only encumber the land that you have on a deed. So it would be his deed that would have to have that encumbrance on it.
We'll acknowledge that you're over here and that you got a problem down there.
We're going to get to the bottom of it, because I firmly believe, like I said, I went down there and got a dog when I was a kid, passed on the field. I drove right past the old Joanna's place. If that helps you. Does that help you any, the old Joanna's place?
No, I don't know where he lives.
You didn't know where he lives? Well,
No.
this is right by. And this is where Bill Payton lives.
I haven't been out that far.
Okay,
Yeah.
now that's, the people that own his old property, or part of his old property, is the one that's blocked the road. And,
Well,
that's the problem.
we will make note that you're here.
Okay, and we will,
And
I'm
we'll-
sure we'll be back as soon as we
Okay.
close the details.
All right.
Danny, thank y'all.
Yeah, thank you all for listening to us. Anybody got anything to add? Chris? Earl? Marty? Pearl? I do. Hey, I'm sure we'll be back. Thank you all.
Thank you.
Where'd you get up off there?
Do it before we do that last item.
Okay. I make the motion to go into closed session.
We'll have a
And this would be
conversation.
for personnel issues and lawsuit issues.
Yeah. We've heard.
Second.
All right. Everybody in favor? Aye. Okay, do I hear a motion to go back into session?
I'll make it motion.
Denzel made it, second. All in favor? For those of you that don't know, this lady back here is Cassie Baker, and she's going to become our new employee here. And starting the 18th of September, I believe, is that right? 19th, okay. So, do I hear, no, we got to put all this in the same motion?
Well, but Miles is secretary,
Okay,
and I'll go ahead and make a motion.
I'll
Okay.
second that. That's back there.
explain to her what we're doing with the lawsuit.
We can put that in the record as well. I think the motion that Denzel is referring to is making Cassie Baker the position she's been appointed to, and to reinstate the line item of the budget that's already been approved for the year for my receptionist. Yeah, I don't know how you'd say it.
I don't either.
That's what it was.
Okay.
And then the London part.
Yeah, and the Lonergan part, which is basically that we would concede and concede only liability with regard to quantum merit in the S&R Holdings lawsuit against Morgan County.
That's saying that we do, yes, we do own,
We owe them something,
but not.
but it's nowhere near $954,000, and that's the word that you can.
Can I have this?
Yes. We'll need to sign that, but yeah.
Okay, so that's all in one motion?
No.
Okay.
That,
The lawsuit is a separate motion.
yeah.
And that's just reinstate fiscal court pay for county attorney receptionist, previously in budget.
Are you going to say, mention Ms. Kendall's role tonight?
I mean, we can, just get all the paperwork turned into that, or what are you gonna set up for the first house?
What road is that?
She wouldn't name it Cantrell Doolin Road, but you said something else.
Cantrell Goins, what she told
Okay.
me. The Goins is the people that bought the property
Yep.
just behind it there. And it belonged to their daughter to start with, her daughter. I think one of the lenders got it back and then they sold it to these Goins people. They live there. It's not over, what?
It's not very long, especially not from the first house right there.
Where the Doolins?
She was a Doolin to start
She was a
with.
Doolin before.
Bazzy?
Yeah, his sister. But Basley Jr., not Basley the third. Basley the third is when that business out here was closed away. Now, make it,
Yeah.
all right.
Put it in once she gets all the paperwork and all that up to the first house, as long as all the paperwork and everything goes through.
Second.
All in favor?
Aye.
But we haven't been taking any roads in.
We'd still have to give notice and allow somebody to come up and say, I don't want this county road. But we do need the deeds and we need to sign off on more than 50% of the property owners, wherever the road is.
Her and one of the property owners.
Both.
I didn't think you'd give notice to take one in, I thought just take one out.
Got to give notice on everything when you're affecting people's liberty interest. If they think it's their land, you got to tell them about it. If they think that a road should be changed, even if they don't even live in the area, then you got to put it in the paper and give notice.
What if you have one to say no?
As I said before, it makes it harder. You can always take an eminent domain. You can do other things. That's why I always like, if everybody signs off on it, there's never going to be a fight later. If they do, then there's going to be a fight. We'll win, but it'll still be a fight. And you don't have
Get all that, Jennifer?
Well, did you actually make a motion on the lawsuit? Okay,
Yeah, you got the paperwork there. for us to
okay,
sign.
so we're not making a motion on that.
Yeah.
No, well, I guess you got to go through the motions one by one there
Okay.
that we voted on.
You think we should get it all worded up?
I'd use this one word. 2 words.
Well, we're gonna refer to this, right?
Yeah.
Okay, yeah.
All right. You satisfied? Okay.
You ain't got no motion on the jury letter or anything.
That's what she's
Yeah,
saying. It's
that's what-
just.
yeah.
He got
Yeah,
one
she's got
typed
it.
up there, I think. Do we all
Does anybody
need to
want-
sign that, or just?
I don't think we got a motion to do it yet.
Yeah.
No, we don't. And not the other one either.
All right, do I hear a motion that we do what Miles said about the London suit? Anthony made it. Second? All in favor? Aye. All right.
I'll give you a copy. Yeah, I'll give you a copy of this. It's pretty much says what it is. And it's just basically saying we own something, but it's not $954,000. Not anywhere near it. And it's what brought this on was a motion for summary judgment by the attorneys for S&R Holdings saying that Morgan County doesn't have a case. We are saying that Morgan County definitely has a case, that there was no contract, and even if what they have is considered to be a contract, it definitely has no price on it. We're saying that, however, we do concede what's called liability from quantum merit, based upon they did come into our county, we didn't kick them out, and we got services from them. We do owe them something, but as I said before, it's not what they're claiming, not anywhere near that. And that's the only thing that we voted on today. We owe them something, but not nearly what they're saying.
Okay, Jennifer, you clear on the others? Okay. All right, we need the approval of the monthly bills. I'll make a motion. All right.
Second.
John second, all in favor?
Aye.
Okay, anything else?
I'll make a motion to adjourn.
All right, second.
Second. Get out of here. We talking about that.
We got about 2 hours in that.
And I-